So 7 cases dealing with assault weapons bans and also magazine bans have now been distributed to the Supreme Court for review at conference, and this is happening in just 2 weeks. So let's talk about what is happening. Now, real quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are not actually subscribed to the channel. So if you guys want to support this channel, if you want to help this content get out to more people, please consider subscribing to the channel. That really does help the channel to grow. It triggers the algorithm and lets it know that, hey, this information is important. It needs to get out to more people. And so again, it's something free to do if you guys want to support the channel. But regardless, thank you all so much for all of your support. As I mentioned in the intro, we're going to be talking about how 7 cases have now been sent to the Supreme Court for conference and for consideration in just 2 weeks. These cases set up a critical Supreme Court reviews of statewide bans on so-called assault weapons, these rifle bans, and then also magazine bans. These rifle and magazine ban cases originate out of 2 specific states. You have the Bianchi versus Bruen case, which involves a challenge to the state of Maryland's ban on so-called assault weapons and then also their magazine bans. And then you have 6 other cases which involve a challenge to the new Illinois Protect Illinois Communities Act, or PICA. And now all these challenges have been scheduled for Supreme Court conference and consideration on the same day, and this is happening in just 2 weeks. You may recall that recently the Second Amendment Foundation and other plaintiffs in the Bianchi case filed for a writ of cert before judgment in the United States Supreme Court. And again, that's a challenge to the Maryland ban on so-called assault weapons. That came after the Fourth Circuit recently decided to play a ton of games and took the Bianchi case out of the hands of the lower court after it was sitting for almost 13 months. Now, for those not aware, the state of Maryland and its ban and this challenge here essentially is in relation to how Maryland identifies certain rifles as so-called assault weapons. Maryland bans the sale, transfer, and possession of semi-automatic centerfire rifles with the detachable magazines and then 2 offending features. Those features could include things like folding stocks, flash suppressors, forward vertical grips, and a lot of other characteristics. This ban was challenged in a Maryland federal district court, and in the complaint, the plaintiffs had to concede that their Second Amendment claim was foreclosed at the lower court level based on a prior Fourth Circuit en banc panel decision on the same issue. A prior case called Colby challenged Maryland's ban on so-called assault weapons. In the Colby case, the en banc panel in the Fourth Circuit upheld that Maryland ban and found that it was constitutional. They ruled that these rifles are outside the protection of the Second Amendment because they are useful in military service. This military use test is still being used by the Fourth Circuit en banc panel and the Fourth Circuit at large, and then also other circuit courts, including the Seventh Circuit, who also reviewed all the PICA cases and the challenge there to the new Illinois ban. This military use analysis runs contrary to what the Supreme Court said in McDonald, Heller, Bruen, Caetano, and other cases, but lower courts like the Seventh Circuit and the Fourth Circuit continue to use that analysis. This case, Bianchi conceded that Colby is the controlling precedent, but that it's incorrect and should be reversed. The district court in this case, Bianchi, ultimately dismissed the complaint because they believed there was a failure to state a claim. The dismissal was then appealed to the Fourth Circuit, and the Fourth Circuit once again upheld that dismissal. Then this Bianchi case made its way up to the Supreme Court for the first time, and that was back in 2022. The Supreme Court ultimately ruled in a different case, a landmark Second Amendment case known as New York State Rifle and Pistol Association versus Bruen, and they found, among many things, that the correct way to review Second Amendment cases is to look at the text of the Second Amendment in light of relevant history and tradition. Again, the relevant history and tradition is that which dates back to 1791. The burden is on the government to find that there is a historical analog that dates back to 1791 to justify the restrictions. If they cannot justify the restriction, well then their restriction must be struck down. Also keep in mind there is the Heller and prior precedents that also are still in place that talk about common use for lawful purposes and that there cannot be an outright ban on something that is an arm. After issuing that ruling, the Supreme Court then issued a GVR in the Bianchi case. That means that the Supreme Court granted review, vacated the judgment down below, and then remanded the case back down to the lower court for reconsideration in light of what they said in Bruen. But as I mentioned, the Bianchi case then sat for 13 months and nothing happened. There were oral arguments, but then there was no decision for 13 months. And then suddenly the en banc panel in the Fourth Circuit took control of the case, and they did that to avoid any pro tuae decision. Now, instead of waiting for the Fourth Circuit en banc panel to review and decide the case, the awesome team over at the Second Amendment Foundation, the other plaintiffs like Firearms Policy Coalition, and a bunch of other plaintiffs filed for a petition for a writ of cert before judgment. This is a completely different mechanism for early Supreme Court review. This essentially is a way to bypass hearings and rulings in the lower courts and instead go directly to the Supreme Court for an actual ruling on the merits. But the state of Maryland responded, and they argued that not only do they think the Bruen case did not in fact change the outcome of the Maryland ban at all, but also that this issue is too premature for Supreme Court intervention. Now, as many of you are aware, the Maryland case is not the only case which challenges the whole incorrect military use test, and is not the only case that's challenging rifle bans and magazine bans. Multiple cases out of the state of Illinois are currently seeking early Supreme Court intervention in challenges to PICA. PICA was passed in an effort to essentially ban all semi-automatic rifles and magazines within the state of Illinois. Multiple cases challenged that law, and originally in a few of those cases, a lower court, a federal district court judge, Judge McGlynn, issued a preliminary injunction against that ban. So he put a temporary preliminary injunction in place blocking that law. Illinois then appealed that preliminary injunction and that decision up to a 3-judge panel in the 7th Circuit. But ultimately, that 3-judge panel in the 7th Circuit, which was made up of some of the worst, anti-gun, progressive liberal judges, ultimately they reversed that preliminary injunction, finding that there was no likelihood of success on the merits. And in their opinion, they believe that these types of rifles and magazines are in fact useful in military service. After that clearly incorrect decision, the 7th Circuit en banc panel was then petitioned for review, but ultimately the 7th Circuit en banc panel denied review of all these Illinois cases. That has now led multiple cases filing for writ asserts to the Supreme Court. Now, to be clear, all these Illinois cases are currently still interlocutory appeals, and they're not final merits decisions and final merits reviews. Also, keep in mind that already twice the Supreme Court has denied emergency applications on early intervention in 2 Illinois cases. That was the NAGR case and then the Kokens case. But in these cases, the plaintiffs are trying to use the fact that multiple lower courts are outright defying the Supreme Court's decisions as a basis for the Supreme Court to now finally get involved. Second Amendment Foundation and the other plaintiffs in the Bianchi case recently used the whole Maryland's arguments that it's too early for Supreme Court intervention, that it's not time yet, let the lower courts review this. They used those arguments against the state of Maryland. They argued that petitioners agree with Maryland that this court's decision in Bruen left Heller undisturbed. But that fact undermines Maryland's position. With respect to timing, this court decided Heller in 2008, which refutes the argument that it is too premature to address the question whether state bans on common semi-automatic rifles are consistent with the Second Amendment. With respect to the merits, a straightforward application of Heller demonstrates that Maryland's ban is unconstitutional. As Heller holds, and Bruen repeatedly confirms, law-abiding citizens have an absolute right to possess firearms that are in common use for lawful purposes. And there can be no question that the rifles Maryland bans are in common use. Indeed, they include the most popular rifles in the history of the nation. To be sure, granting certiorari before judgment is not typical, but neither is the sua sponte seizure of this case by the en banc panel in the 4th Circuit 13 months after argument, nor is the continued incapacity of lower courts to grasp the plain teaching of Heller in this context. This court should grant certiorari to make more explicit what should have been apparent with the issuance of Heller in 2008, that the government simply lacks the authority to ban commonly possessed arms. What the plaintiffs are arguing here is that essentially they agree with Maryland and other states that the 2008 Heller decision should control this case and other cases. And because of that, this case and all the other cases are in fact completely ripe for Supreme Court review. It is now time for the Supreme Court to review this issue. The fact that lower courts still are incorrectly applying Heller 16 years after that decision means that it is time for the Supreme Court to finally step in. And now the Supreme Court will get together on May 16th for conference, and they will review the 7 rifle cases and these magazine ban cases. And at conference, the Supreme Court will consider and ultimately decide whether or not they're going to grant review to these cases. And it only takes 4 justices to grant cert to these cases. Typically, the following week after conference, we will receive an order list from the Supreme Court, and it will indicate if they've granted review or denied review to these cases. So that's what's currently happening right now with all these rifle magazine ban cases that are now seeking Supreme Court review. So if we get any more information, if anything else changes, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.